Next, we talk to attorney Aaron Maduff, who is representing the State University's Annuitants Association in their lawsuit against the state over pension reform. Mr. Maduff gives us an update on the lawsuit, as well as the chance of its success in lieu of the recent Kenova v. Weems ruling, in which the Illinois Supreme Court ruled that healthcare benefits for state workers are protected by the Pension Protection Clause. This runs about 25 minutes.
Aaron Maduff, thanks for joining us again on the Illinois channel. As we tape this on the 22nd of July, you just came from another hearing in the suit against diminishing or cutting the pensions. The bill was passed. What is the latest of what happened in the court today?
Today was just a status. There wasn't a whole lot that we expected. At the last status, the court had set dates for the state to provide its list of expert witnesses, which is the end of this month, and at the end of August, the state is to give us their actual expert reports. We hadn't gotten to the end of the month yet. The state has not yet given us the list of expert witnesses in terms of its amendments. It has given us 5 so far. They told us today that they're going to be adding a 6th, but the court wanted an update.
Who's the attorney? Who's the lead attorney representing the state?
The state today was represented by Brent Stratton from the Attorney General's office, but on the phone was also Doug Reese and Richard Hussack.
You know, one of the major things that's happened since last we spoke, on July the 3rd, the court issued a decision in a different case called the Weems case, and there was a very significant ruling where the Illinois Supreme Court came down and said that basically the health care benefits of state workers are as protected as pensions. That's at least a law meant. They are a pension benefit. I wanted to get your thoughts on that, and to what extent, if any, can we interpret that ruling and how it might apply to the case you're working on, which is the suit against the law that was passed cutting pensions.
Justice Freeman's written opinion in Kenova v. Weems is a sweeping one. It was a 6-1 opinion. There was a dissent by Justice Burke. But essentially, the issue in Kenova was whether the health care benefits that were being taken out by Senate Bill 1313 were pension benefits protected by the Pension Protection Clause. Now, when that case was filed before the Circuit Court of Sangamon County, many claims were brought, the Pension Protection Clause being one of them. Just like we've brought contract claims here, they also brought contract claims in that case. The Circuit Court of Sangamon County dismissed that action altogether on the basis that the health care that was being granted free of charge to pensioners was not a benefit protected by the Pension Protection Clause, and therefore simply dismissed the case before the state ever filed an answer in that case. In so doing, it also dismissed the contract claims for other reasons. The case then went up to the Supreme Court, and the Supreme Court reviewed primarily the question of whether or not these health care benefits are pension benefits protected by the Pension Protection Clause. And the majority opinion, by a vote of 6-1, concluded that indeed they are pension benefits, they are protected by the Pension Protection Clause, and remanded the case. But there are some interesting things that happened during the course of that case. One of them is that the Supreme Court did not address the contract issues, and that leaves some puzzled. The Supreme Court said the plaintiffs have already received everything that they have been asking for, and therefore we're not going to get to the questions regarding the contract issues. Why is that important? Well, I said a moment ago that in Kenova, the state had never filed an answer. Since it didn't file an answer, it also did not file an affirmative defense, namely the reserved sovereign powers or police powers defense that it has filed here. So technically, that police powers defense was never before the Supreme Court. So conceptually, what could happen is that the Supreme Court says these health care benefits are pension benefits, kick it back down to the Circuit Court, and the Circuit Court says, all right, now I have to go forward and rule on the case, and the state now raises the police powers for the first time, and the court has to determine whether or not the police powers is a defense and whether or not the police powers are met as a defense in that case. However, because the Supreme Court said we're not going to get to these other issues. If that were to happen, if it were to come back down and the Sangamon County Circuit Court were to say the police powers defense applies, the plaintiffs lose, the plaintiffs will have lost on contract claims that they were never able to present. That would be a violation of due process. So the implication is that the Supreme Court has taken the view that the plaintiffs never need to get to those questions because the Pension Protection Clause is simply immune from the police powers defense in the first instance, which is what we have been saying in this case. So Kenova has two very clear implications for us. Number one, the question of whether or not any part of what we are claiming is a pension benefit is, I think, dead in the water. We know that it is. For example, the state has suggested that the AAIs are not a pension benefit.
And what is an AAI?
The annual annuity increases. So we have challenged a number of portions of the Pension Reform Act in and of itself. We've challenged the change in the ERI. We've changed the change in the retirement age. We've challenged the diminishments of the annual annuity increases, etc. And one of the things the state has said is that the annual annuity increases are not a core benefit, whatever a core benefit is. And therefore, they're not protected by the Pension Protection Clause.
Is that the same as the COLA?
COLA is a term that has been used, but a COLA is generally a cost of living adjustment. That's what COLA means.
Right.
And it is generally based on the Consumer Price Index. That is, we're going to raise what you have by a measurement equal to the raise in consumer prices to keep up with the cost of living. The AAIs are simply a 3% compounded increase, and they are not based upon the Consumer Price Index. So as a result, they're a benefit that is not going to be held down because the CPI may increase by less, and so we call them AAIs. We call them annual annuity increases. And they are...
And your argument is, I think the state, when you core benefits, the state would say, we promise to pay you, I'm going to make a figure up, 75% or half, let's say half of your final salary is a pension. They would argue that's the core benefit. The increases along the way are not part of that agreement and are subject to change. Your argument is that that is part of the pension benefit.
Right. That is exactly the argument the state has made. I think you've hit it on the head. And in fact, the answer says literally it's not a core benefit. Now, the term core is something that doesn't have a lot of meaning to me. It either is a pension benefit protected by the Pension Protection Clause, or it's not a pension benefit. I don't know what the state means by core versus not core. But the implication is that the state has taken a view that the AAIs are not protected by the Pension Protection Clause because they're not a pension benefit. What Kenova certainly does, without question, is it says that anything that you have by virtue of your being a member of the pension system is a protectable pension benefit. And so what Kenova did is it said that you have these, this free health care as because you're a member of the pension system. Therefore, it is a pension benefit. Therefore, it is protected by the Pension Protection Clause. Well, by the very same analysis, the AAIs are something that SUAA members have, as well as other pensioners have, by virtue of being members of, for SUAA, SURS, the State University Retirement System. And therefore, they are without question a protectable pension benefit. So that really kills that argument, I think, altogether.
So as a result of Weems, state workers or retirees getting free pension, or free health care rather, the state can't come back and say, we're going to start charging you $250 a month.
Well, this is part of the question that's out there. If what the Supreme Court means is that this case is done, then that's correct. If the Circuit Court of Sangamon County says, wait a minute, the state never raised its affirmative defenses, and so therefore the Supreme Court never considered the affirmative defense, then conceptually the Circuit Court of Sangamon County could then go through the process, review it, and say that the reserved sovereign powers affirmative defense trumps the Pension Protection Clause claim, and therefore the state can still charge for those health insurance premiums. Our view is that they can't. Our view is that anything that is protected by the Pension Protection Clause is immune from a sovereign powers defense. We've discussed this in previous interviews, but I think that's a core piece of where we're going here.
Oh, let's remind people, what is the reserve sovereign, the police?
The police powers.
The police powers that the state would be arguing. Let's summarize what that is again.
Sure. The state has a responsibility to protect the welfare of the citizens. And so under the police powers, it can take certain acts, which may be violative of other laws or maybe constitutional provisions, to protect the citizenry. The classic example that I might give is everybody knows the First Amendment of the United States Constitution guarantees you a freedom of speech. But we also know that you can't yell fire in a crowded theater. Why is that? Because the state can abridge freedom of speech, even though it's a constitutional protection, for the purpose of preserving the welfare of the people, the concept being that if you yell fire in a crowded theater, you're going to have people getting injured as everybody races for the door. So the state, in raising the police powers, is essentially saying, you know, even if the Pension Protection Clause protects the pension benefits that we're talking about, we can still infringe on it in order to preserve the welfare of the citizenry of the state of Illinois. And our view is that while certainly some things can be infringed by virtue of the police powers, the Pension Protection Clause, given the circumstances of how it was passed and what it means, is immune from that kind of an attack.
Should, you know, obviously the whole reason the state's doing this is because the pensions and the health benefits are eating them up along with other spending. But I mean, it's a rising cost. It's almost like a blank check, and it just keeps growing at a rapid clip. Should the law be concerned about the ability of the state to meet its payments on a financial matter?
I think that that is the argument that the state is making when it raises the police powers. But I think that the Pension Protection Clause, as I said a moment ago, is immune from it. And we are talking here about a problem that is of the state's creation. In 1970, when Illinois redid its constitution, the SURS fund, I believe, was funded at 47%. People were very concerned, my God, they haven't funded the pension, and at some point the state's going to do exactly what it's doing now. It's going to say, we don't have the money, so we're not going to pay the pension. At that time, the delegates to the convention had a discussion about it, and there is commentary that says we're not requiring by this clause, we're not requiring the state to fund the pensions now, but we are making it very clear that once a pension benefit has been earned, somebody is in the system, the state must pay it. And this has to be a wake-up call to the state that you need to fund those pensions. And the state has ignored that wake-up call for 40 years. So now this is a problem of the state's making. And indeed, there is a case called McNamee where the court says, look, you aren't required to fund the pension, but you are required to pay people their pension benefits. It's a warning, and the state has not heeded that warning. I think it is a little bit odd for the state to come back and say, we had this warning that we need to fund those pensions. We ignored it. Now we don't have the money. So now we're going to invoke the police powers and claim that we have some sort of an emergency and not pay the pensions, when the Pension Protection Clause was put in the first instance to ensure that they did.
There's another issue that, and let me insert just as of today, the GOP candidate for Attorney General, Paul Schrimp, said that in his estimation, the pensions are protected by the Constitution and that there is no emergency exception. The law is the law, basically, is what he would say. I mean, as an aside. But the Republican candidate, Bruce Rauner, on the other hand, is saying that you may have earned your pension benefits up through, let's say, the end of this week, even if you've been working with the state for 15 years. And those are protected. But his contention would be that starting next week, in other words, at a certain point and going forward, the state would have the right to alter the plan. Just as if you're working in the private sector, you might make $50,000 a year 1 year, but maybe they have to cut your salary to $40,000 because business is bad the following year. And the employee has the option to keep the job or go seek employment elsewhere. What would your estimation be as far as the legalities of changing pension benefits in the future at some deadline, whether it's January 15 or 2018 or whatever that might be?
Well, I don't know what candidate Rauner's actual comments were, but what you've just expressed to me, that's sort of a middle position, and it's either you have them or you can't. Certainly the law does not support, in my view, the description you've just given me. Either the police powers come into effect and the state can change those pensions or do what it wants, or they can't. What is clear is that your pension vests the minute you come into the system. Whatever the rules are when you come into the system, those are the rules that are going to apply to you when you retire, no matter what the changes. There's a case going back to the 19th.
But let me insert, would that be the case, though, if you haven't retired? In other words, I think a lot of people would say, we accept your argument that someone's retired, they had a deal, they worked their job, they retired. But if they're still an employee, you can't change it retro, but you can change it going forward.
That's not consistent with the law at all. That's the one argument that doesn't work. It may make certain logical sense to us as individuals when we look at it, but when we look at the law, and that's why I was talking about this Bedell case going back to the 1960s, what you have is that if you enter the system, you've taken a job. Now, try looking at it from this perspective. When you make a decision to become a professor at a university, you're taking what that job is. You may have turned down a whole lot more lucrative possibility at some pharmaceutical company rather than becoming a professor of chemistry. But you know that when you retire, you're going to have these pensions. And now you don't have the opportunity to go off to that pharmaceutical company because you spent 20 years in academia. And that shift is something you can't do. And now the state's going to come back and say, oops, sorry, you're not going to get those benefits at the end of your career that you thought you were going to get. That's not right. And what the law says is, and that we go back to this Bedell case. This Bedell case is a situation where a police officer wanted to take credit for, I believe it was disability or military, I don't remember specifics. And they changed the law and said you have to do it by, I think, 1974, and he didn't. He did it in 1976. And the states or the system said we're not going to permit you to do it. And the Supreme Court said no. When he went into the system, these were the rules. The rules were he could make that election whenever. You cannot change the rules on him. That's part of a pension benefit. By the same token, whatever the benefit is when you go into the system, if you are going to find that the Pension Protection Clause protects the pension, whatever the benefit is, going into the system, that's the benefit. The only way that changes is if you buy the state's argument that either A, it isn't a benefit, which I think that Kenova versus Weems really puts an end to, or B, that with the reserved sovereign powers, they can violate the benefit. But you can't find a middle ground that says, well, you do have a benefit, it is protected, but it can be changed on you. I think the law is pretty clear on that.
You know, I would point out to people, Senate President Cullerton had I think a strategy if the case before the court that you're arguing on is thrown out as being unconstitutional, that he was going to go back and say, we'll, as he had suggested, we'll trade off health care benefits for some acquiescence by the recipients of the pensions to take a lower pension. So the one thing is the Weems decision would gut that strategy. That would no longer be a trade-off that would be viable.
I'm not sure I agree with that, because the Pension Protection Clause specifically says that a pension is a contractual relationship which shall not be impaired or diminished. We can go back to contract law. If you and I have a contract that I'm going to do something for you for a certain price, I can't go in and do the same thing and raise the price. But we can always renegotiate the contract. You can come to me and say, I want you to do something more, and I can raise the price.
Well, then where would the Weems apply? Just to those who are already retired, but not to current employees?
Where Kenova versus Weems applies is to the law as it stands. The Senate Bill 1313 purported to simply go in and say we're going to start charging you for health care. And you can't do that because you're not getting anything for it. A contract is an offer and acceptance and something passing between us, and you cannot limit your responsibility unless you're giving something else. But any two parties can say we're going to renegotiate a contract. So Senator Cullerton's concept of we can sit down with people and say, look, we're going to give you the health care and we're going to increase it or we're going to do something. And we're going to have you give us something for it. That's a new agreement. That's a contract. Now, how you do that, And the complexities of that is something that I'm not aware of what he has planned or how you go into. But the concept of renegotiating is certainly something that can be done.
So, just to make it clear, there's a contract with the AFSCME, which represents a lot of the state workers. You're saying at whatever time the current contract is over, when the new contract is being negotiated, it's conceivable you could do that kind of a deal at that time.
I'd go a step further than that. Even while a contract is pending, if AFSCME wants to renegotiate and the state wants to renegotiate, they have the right to renegotiate at any time. But you can't have an exchange where the agreement is, I'm simply not going to give you anything.
It can't be a unilateral, one
Exactly.
party just changes the deal.
Right.
Okay. Before we close out, is there anything else we should be considering?
Well, Kenova does have some serious impact on this litigation. It certainly has impact on the health care questions. But we still have to go through the process. Right now, the Sangamon County Court in the pension litigation that SUAA is involved in so far has determined that we're going to go through all of the steps. That means that we're going to have to get those expert reports. We're going to have to depose those experts. We're going to have to present the defenses and present evidence to contradict it, to put the whole issue before the court. The court may, in the end, agree with us that the Pension Protection Clause simply protects it absolutely. But there's a long battle here that we still have to go through. Even if we think that we're likely to win, we can't just sit on our laurels and give up. There's a long fight ahead of us and a lot of work that still has to be done.
All right. Aaron, thank you again for joining us.
You're very welcome. Thank you.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.